Well, the High Court in Pretoria has set aside the report issued by the Public Protector last year on her findings on an investigation into the so-called rogue unit at the South African Revenue Service. Advocate Busisiwe Mkhwebane's report found that the setting up of the unit approved by Pravin Gordhan was in violation of the Constitution. While to unpack today's judgment, we're joined by Bernard Hotz, who is a director at Werksman Attorney. Good evening and thank you so much for your time. Firstly, when we look at this report, it has been quite scathing, especially on the part of the Public Protector and the extent to which she did her background and her homework in terms of investigating and really questioning the kind of evidence that she relied on in that report. Is this ruling by the full bench, is it definitive for now?
Well, good evening. Yes, indeed. But I think we need to start a little before that. First of all, what the full bench found is that, in fact, this report should never even have gotten out of the starting blocks because the Public Protector failed to comply with her own act dealing with the jurisdiction to entertain claims that are older than 2 years old without special circumstances existing. So that's also very important because the full bench held that they could simply dismiss, review, set aside the report on that basis alone. But they went further. They said, look, let's go and analyze what the Public Protector did and didn't do. And in fact, what they said is that the Public Protector took no measures to actually analyze the evidence that had been placed before her by Mr. Pillay, Mr. van Lochenberg. Instead, she chose to rely upon reports which came from who knows where, discredited reports from people who have over the years been shown to be unreliable. She took absolutely no steps that the judges say she ought to have taken in order to uphold the purpose and the sanctity of her office.
One of the things that we see is the mentioning, as you've said, of multiple reports of evidence by some of the witnesses, but also, the Skakani report, the Kroon Advisory Panel, the KPMG report, and the report by the Office of the Inspector General of Intelligence. The judge's feeling that, these documents were not necessarily to be relied upon. And yet we also know that these are the very same documents that have divided public opinion. They've divided the political space, and they themselves are very much in question. And there seems to be a narrative that says, well, if you don't believe perhaps some of the issues that the Skakani report had raised, then it's simply because of the political formation or grouping that you might belong to.
Let's deal with them. First of all, the Sikhakhane panel report, there was an error in law. The judges have now definitively said that the finding by the Sikhakhane panel that this unit was unlawful was wrong in law. They've said that Section 3 of the NSI Act does not apply to the unit that SARS set up. And they said furthermore that the Public Protector provides no reason why she persists in relying on an interpretation of the Act that has been considered to be wrong. That's Sikhakhane. They also deal with Sikhakhane, and they say that Sikhakhane went beyond the mandate, and in going beyond the mandate, didn't even offer the opportunity to those people who had been implicated to come and give their version, but jump to a conclusion. That's Sikhakhane. KPMG, well, let's deal with Judge Kroon, retired Judge Kroon. Retired Judge Kroon has already said before the Nugent Commission, which the Public Protector paid scant regard to, but retired Judge Kroon said before the Nugent Commission that he and his panel had relied upon Sikhakhane. They've realized that Sikhakhane was wrong, and in fact, Judge Kroon not only apologized, but he also said that this unit plays such a crucial role within any revenue collection agency. That's the Kroon report. KPMG, we don't even have to go there because that report has been debunked in its entirety so many times that it's definitely not worth the paper it wasn't written on.
There's an issue that has been raised by other lawyers, and this is the code of conduct that Advocate Mkhwebane used when determining the wrongdoing, at least on the part of the Public Enterprises Minister, Pravin Gordhan. And they say that, she was relying on the latest legislation in terms of the Ethics Code of Conduct of 2007, where it seems very much that the judges may have relied on an older version of this Code of Conduct of 2000. Bernard, what do you know about that? What can you tell us about that particular argument?
Well, the judges were quite definitive on that, and their line in the conclusion was simply the public protector's conclusion on the evidence in that the code can be violated even inadvertently is based on an error of law. It's not the judges who got it wrong, it's the public protector who got it wrong and refused to accept it.
So what does this mean now? I mean, there's still options that are available to her, because when one looks at some of the tweets that the public protector has been putting out, she believes that, these decisions against her are in fact part of a coordinated effort to discredit her office. What's the legal recourse that's available to her?
Let's distinguish between the office of the public protector and the incumbent. I don't think that anybody would believe that the importance of the office of the public protector can never be undermined. However, the actions of the incumbent have been adjudicated upon by numerous courts, and in fact, if one looks at the judgment that the court said today, the judges granted a punitive costs order against the public protector in her personal capacity. And what they said is as follows. They say, where a public office bearer does not hold herself to this high commitment to public office, as we have found this to be in this matter, a personal costs order is warranted. In the present case, we hold the considered view that the public protector has not met the requisite standards. The fact that the public protector displayed dishonesty in respect of the OIGI report is on its own deserving of censure by this court in the form of a personal costs order against her. That's what the judges said. As simple as that.
If the Public Protector's Office decides to take this case on review, what are the chances of success? Do we have, I suppose, a success rate ratio when a judgment has been delivered by a full bench, and what the appeal success rate is when it comes before the Supreme Court of Appeals?
Let's just talk about correct terminology. There's no such thing as taking this judgment on review, unless the public protector is going to allege that the judges have conducted themselves in an objectionable fashion. The correct thing is to apply for leave to appeal the judgment. The test there is, roughly speaking, is it possible that another court could come to a different conclusion? Well, here we have 3 judges, a unanimous judgment, all of whom have said that this report should be set aside and the public protector should be mulcted with personal costs on a punitive scale. Yes, of course, apply for leave to appeal. That's what the legal system provides. The leave could be refused, it could be granted. Ultimately, the Supreme Court of Appeal and the Constitutional Court may one day be called upon to opine on this. But we have a 111-page thorough judgment written by 3 judges who took the time to go through not rhetoric, but evidence and facts placed before them, something the public protector didn't take the time to do when she issued her report.
Bernard Hotz is a director at Werksman Attorneys. Thank you so much for your time tonight.